We've all got very different ideas about lawyers, and for most of us, we have those different ideas within ourselves. We look to lawyers as both blessing and curse depending on the context. And that is certainly true when it comes to the criminal justice system. The videos that you need to have seen before you watch this segment really illustrate two very powerful ideas about different lawyers in the criminal justice system: the perspective of prosecutors and the perspectives of criminal defense lawyers. And they're both very idealized insofar as they represent people at the best of their game, most passionate about what they want to do within the criminal justice system. That certainly represents truths in the system, but as I hope you might have guessed thus far into the class, the reality is much more along a spectrum. So we're going to start off by talking about prosecutors and then go on to defense lawyers. Arguably, prosecutors are the single most powerful actor in an institutional sense in our criminal justice system. They are arguably more influential in shaping our criminal justice system than any other kind of job, whether we're talking about mayors or governors or criminal defense lawyers, or even the President of the United States. In other words, prosecutors as a group have enormous influence in the criminal justice system, which doesn't mean they can or do always get their way. They certainly don't. Let's start off by noting that at the federal level, prosecutors are appointed. At a state level, like everything else, it depends on the jurisdiction, but they may be elected or appointed or work in different kinds of ways in different kinds of offices. Prosecutors are going to be concerned with all aspects of the criminal justice system, from arrest to final disposition of a case, which is one of the reasons they have such power, because they can and do make decisions that have a powerful influence in shaping the defendant's likely fate. So, for example, the prosecutor can decide whether or not to charge somebody, or how many charges to charge them with, or whether to negotiate a plea or not to negotiate a plea, and what sentence to recommend. Those are enormously powerful things and ways in which a prosecutor can shape what happens to an individual case and an individual defendant in the system. Something that adds to prosecutorial power is the fact that their decisions and actions take place away from public view to a very large extent. The part we see of prosecutors when they're in the courtroom or interviewed in the media is a very small part of their job. Behind many of these decisions is an immense amount of prosecutorial discretion, because what is shaping not just their responsibility but their ability to make certain decisions is this discretion. And this comes into something that we'll be talking about in a separate segment when we talk about trials and, more importantly, plea negotiations, because the discretion of the prosecutor increases or decreases the number of bargaining chips they might have in deciding how to charge, whether to bargain, whether to negotiate or not. However, defense attorneys can also be quite powerful. In general, however, their resources and their ability to shape the system do not nearly match those of prosecutors. Let's just remember that prosecutors represent the government or represent the people in arguing the state's case against a criminal defendant in a criminal case. In contrast, a defense attorney or a criminal defense attorney represents suspects and defendants, and occasionally also convicted offenders, but that's pretty rare, in their dealings with the criminal justice system. It's up to the defense attorney to advise the defendant and protect him or her in terms of their constitutional rights at each stage of the criminal justice process. However, in practice, if you are an indigent defendant, remember that means if you're a poor defendant and you cannot afford a lawyer, you may or may not have the right to have a defense counsel at each stage of the process. If you do have a criminal defense attorney, you can use that criminal defense attorney to help advise you if you're a defendant when you're being questioned by the police, when you're being represented at arraignment, or when you're engaged in a hearing, as well as in the trial process. A defense attorney is also going to be important for the appeal process. The fact that we mentioned the affordability or not of defense attorneys is a critical issue, because in many ways the really big issue in defense is not whether or not you have a lawyer, but whether or not you can afford a lawyer and what happens to you if you don't. Hopefully you remember from Gideon versus Wainwright that the Supreme Court ruled that those who cannot afford lawyers and are facing felony convictions, and later that was expanded to people who are facing prison or jail time of a certain amount of time and certain other categories, are entitled to lawyers paid for by the state. The reality, however, is that that Sixth Amendment right to counsel, as interpreted by Gideon and subsequent decisions, has been profoundly narrowed by the real-world practices of how much money is available to provide for indigent defense. There are lots of different ways states and the federal government have a right to provide for indigent defense. The federal government in many states use a system of essentially taxpayer-subsidized criminal defense lawyers to represent people. But lawyers can also be appointed on a rotating system by a judge using the local bar. States can also have contracts with criminal defense counsel. Although there are a lot of disagreements about all sorts of aspects of politics, including the criminal justice system across the political spectrum from left to right, one of the things almost all people, especially those who work in the criminal justice system, agree on is that one of the biggest problems we have in our criminal justice system is inadequate defense of indigent defendants. That's because although we have a legal right to indigent defense, in practice, the resources available for people who are too poor to get their own counsel tends to be way less than the actual demands on them, especially in many states. And so the real challenge for indigent defense is not to get a public defender, but to get a lawyer who can give them the time and resources they need. The big difference between people who are engaged in the criminal trials that really get our public attention and the vast majority of criminal trials that happen underneath tends to be an issue of resources. Let's take a very famous case like the O.J. Simpson case, for example. People often talk about that case primarily in terms of the issue of race. In many ways, though, what it really tells us about is class. O.J. Simpson had resources that most criminal defendants, even ones who can pay for their own counsel, couldn't possibly imagine. And that criminal defense team was able to get a whole panel of lawyers and experts on juries and paralegals and investigators and all sorts of other things. The vast majority of defendants only see their lawyer in court or just before they go into court. And those lawyers often have tremendous pressure on them to engage in pleas because they simply do not have the time or resources to represent every one of their clients. So what we see when we look at indigent defense is the theory versus the reality of Gideon and an indigent defense more generally. I think that one of the most fascinating ideas I've ever read about how we might fix this problem was one that came from a former Justice of the United States Supreme Court, Sandra Day O'Connor. She looked at an example from England and suggested we might want to, at least on a trial basis, use this idea to balance how we provide for indigent defense on the one hand and the state's interest in prosecuting cases on the other hand. Justice O'Connor said she would ideally like to find a couple of jurisdictions in the United States that would be willing to set up offices of public lawyers that would be equally remunerated or equally paid and assigned to either the defense or the prosecution on a rotating basis. So you'd have to be a top criminal lawyer, and it wouldn't matter if you were a criminal prosecutor or a criminal defense lawyer. And you could, on a random and rotating basis, have to take on either side. Now, in the real world of politics, I don't see that is likely to happen anytime soon, especially not across the United States. But maybe in the laboratories of democracy that are the states of the United States, we might have some brave politicians who were prepared to, on a trial basis, try the system and see how the system changed when we had defense and prosecution getting equal resources and being taken equally seriously by lawyers who were passionate about criminal justice, whether from the prosecution or the defense side.